Hi everyone, my name is Bazikyan from Bazikyan Law Group. I am an estate planning attorney here in Los Angeles, and this month I wanted to tell you about the best way to avoid the probate process here in California. And this is a process that we have in the state of California. It might be different from other states if you're watching this video in other states, so consult with an attorney in the state that you're living in. But in California, we have a process called probate, and that's the process through which we channel or funnel a person's assets when they have passed away and give them over or hand them over to their loved ones when they have passed away. So it's a formal court process that a loved one's estate has to go through when they've passed away, unless they've done a few things to avoid the probate process. So I'll tell you about the best way to avoid probate at the end of this video, but for now I want to give an example to help us illustrate why probate is so terrible and why we don't like it. So let's say that John has one home in like Van Nuys, it's worth $600,000, and he has a $500,000 mortgage on it. Other than that, he really has no other assets. He has some bank accounts here and there, but they all have a value of a couple of thousand each, no more than $10,000 altogether. So if John has done no planning whatsoever, or if John has written up a will and nothing more, his total estate, and when we say estate, we're referring to the property and his bank accounts, they will go through this formal process called probate, and they will end up in the hands of his loved ones. So what we don't like is this probate process, and the reason we don't like it here in California is that the word probate is synonymous with the word expensive. It is a very expensive process here in California. To probate John's home, which is valued at $600,000, and he has a mortgage of $500,000, so the net equity that his loved ones are going to be extracting from that probate is only $100,000 in equity. To do all that work for $100,000, at the end they're actually not going to be left with $100,000 because the probate expenses and fees are going to add up. So what ends up happening during probate is the court will issue a price on the asset, and when they issue that price, the key thing to remember here that not a lot of people know is they issue that price on the total value of the property, and they don't care if you have a mortgage. So they don't care that the equity that John has is only $100,000. They're gonna base all the probate costs on that $600,000 number, which means that the attorney's fees are gonna be somewhere around $15,000. The administrator, which is the person that is executing the estate or administering the estate, running the show basically, that individual, and it's probably a family member, that individual has a right to also receive $15,000. In addition to that, there's a couple of thousand in court filing fees and expenses. There could be a bond fee, publication fee. So all of these fees add up, and we're looking at about $30,000 to $35,000 just to probate $100,000 of equity through the court system and get it out at the other end to the loved ones. So at the end, the net that the family members are gonna receive is gonna be far less than the $100,000 equity. So this is a very expensive process, and there's some of those fees we can cut out, and this is of course assuming that no one fights, everyone gets along, and it's a very smooth probate transaction. That's the fee for a very smooth probate transaction. If the family decides to sell the house during that process, there's gonna be additional fees for the sale of the property in the probate system. So the attorney can charge extraordinary fees at that point. There's an additional filing fee possibly. So there's additional fees that could rack up. So all in all, assuming that the administrator says, I'm a family member, I don't want my fee, I'm gonna do this job for free. At the end of the day, you still have the attorney fees, which are gonna be around $15,000, and you still have all of those miscellaneous filing, court, publication fees that are gonna rack up. So you're still looking at about close to $20,000 in fees just to administer the estate to get $100,000 to the family members. So the net is going to be far less than $100,000. So in order to avoid this very lengthy process and public process, the best way to do that is through the creation of a trust. By creating an estate plan and making sure that you have a trust as the backbone, you're basically pre-planning what you want done at your death, and making sure that it's done correctly from the get-go. So you're saying, I'm going to spend a couple of $1,000s now while I'm alive. I'm going to put together all these documents, and when I'm gone, there's going to be no need to walk into that probate court. My family is going to take all these documents, meet with the attorney, and they're going to administer it privately in an office without the involvement of the court or judge oversight. So that's best case scenario, to pre-plan, do a trust, get it done in a couple of thousand, and save your family thousands and thousands of dollars. There are some ways that I have seen people kind of doing their own probate avoidance, which doesn't necessarily have great legal consequences. So we see people naming beneficiaries on trust, on actual accounts, and having this be a way of it transferring at their death to loved ones. The only thing I would caution you about for that is making sure that you have an incapacity plan. With a comprehensive estate plan, we're not only covering death, but we're also covering incapacity. So if you're mentally or physically not able to do things for yourself, we have a plan in place for who steps in and does it. If you go ahead and you just designate beneficiaries on certain accounts, great. At your death, it will go to those people without going to probate. But if you don't pass away and you are actually really sick and we need somebody to jump in and use your assets to take care of you, we're still going to have to go to court and get a conservatorship. So we don't want that. And then of course there's quite a few different types of accounts that have what the court calls beneficiary designated accounts, which avoid probate. And those are things like life insurance, retirement accounts, annuities, where you can actually designate the actual beneficiary to take over after you're gone and become a beneficiary. So there's numerous things that you could do. You can hold it in joint tenancy with a loved one, where you bring them in as co-owners with you on a property. That's another method that we see all the time, but as we've discussed in previous videos, there's some negative tax implications for capital gains into doing that. There's also some unwanted consequences, like for example, the person's creditors and being subject to their liabilities. So the best way to do it without exposing yourself to unwanted liability and exposing yourself to risk is to create an estate plan. It's very easy to do. It's very straightforward. You'll get together with an attorney. We'll put together a plan of action. It'll be done. You don't have to worry about it. You could store it away and enjoy the rest of your life. So if you would like to sit down with me, we do offer free consultations at our office. Feel free to reach out and schedule an appointment, and I'd be happy to sit down and discuss your needs and see if we can put together a plan for you. Feel free to reach out. My staff is willing to help you. Thank you. Bye.